1.
The Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Good morning, everyone. The first case for oral argument is 229, People v. Fudge. Good morning, counselors.
Good morning.
Okay, Ms. Carbone, you're on mute. Okay, let's go. Let's begin.
Good morning. May it please the court. Kristen McDermott on behalf of Anthony Fudge. We know that PCP and marijuana are two very different types of drugs. Marijuana has a
Counsel, I'd like to, we have read your papers and understand the distinction between marijuana and PCP. I'm a little concerned that in your papers, you talk about this being a case of first impression. Yet there's 2 appellate division cases, both Darby and Sanchez, at least 2 trial level cases, numerous federal circuit and district court cases, and at least 5 appellate level cases in other states deciding this issue. So I really don't see that it's a case of first impression.
I believe it's a case of first impression for this court. So the Court of Appeals and the 4th Department have never decided that the smell of PCP constitutes probable cause.
Okay, well then moving on to page 11 of your brief, where you're attempting to argue that Darby shouldn't be applied here. I'm concerned that you cite the language about observations regarding other drug dealing without informing the court that the exact language you're citing from comes from the dissent and not the majority. Do you think you have an obligation to advise the court of that?
Certainly, if I failed to write dissent in there, I apologize. That I was only citing that to establish the facts. So not to establish that that was the holding of the court in Darby, but just that those were the facts.
Distinguished Darby, I understood that. It was just that it stuck out at me when I saw that language and went and said, wait, that's from the dissent and not the majority. But I guess the thing that's more concerning to me, counsel, is, look, I recommend, and I recognize that the defense counsel serves a useful purpose. It's my understanding you're really the quality control officer for the police, the courts, the prosecutor, but there are rules and limitations on what you're allowed to do. And what's most concerning to me is what in this record do you believe justifies your repeated statements that it appears the officer lied at the suppression hearing, even though the court found him credible, appears to have made up observations, was likely fabricated evidence to provide probable cause, simply fabricated evidence to retroactively justify the search. Those are pretty serious allegations. What in this record justifies you making those?
So the officer claimed for the first time at the suppression hearing to have observed Mr. Fudge with glossy eyes, slurred speech, and clearly under the influence of something. And this was something that he had never said before. This wasn't in the police report, which we acknowledge was written by his partner, but was written about both of their observations. They didn't give him any.
You wouldn't expect one officer's observations to be exactly the same as the other officer's observations, would you? Otherwise, you'd be telling us that, oh, look, they work together. They're only reciting what the other one said.
Their observations certainly can veer from each other a little bit, but they should generally be describing the same incident. And so when Rochester is confronted with the police report at the hearing, he says that he thinks his partner wrote down essentially the same observations, but just phrased differently. And that was just transparently false. What Brown said was that Mr. Fudge was nervous, gripping the steering wheel and looking around. And so Dorchester's claim, trying to convince the court that these were the same observations, just phrased differently, was a pretty clear attempt, I think, to lie, which indicates he was willing to lie.
You believe the difference between the two officers justifies your allegation that they lied and manufactured evidence?
I do. I think in this case, because that was such a difference, and it was so clear that he was just making something up at the hearing.
Counsel, there wasn't just one person in the car. There were 3 occupants in the car. So isn't it likely that multiple officers are going to be focused on multiple people?
Well, yes, at certain points in the stop, but when Dorchester got Mr. Fudge out of the car and handcuffed him, Brown came around and they were both working on handcuffing him together. Even though he was perfectly cooperative, they felt that because he is a big man, he needed to be restrained by 2 officers.
You would agree, though, being an experienced litigator, that when 2 people see the same incident, they often describe it differently.
That's true. Just to be clear, though, Brown's police report was a summary of both officers' observations. They said that they're partners and they take turns doing the report for both of their observations. But just to be clear, this issue does not rely on this court overturning the credibility determination. The main issue that I raised, this court can find that Dorchester was completely telling the truth and that he smelled what he associated with PCP, the smell that he thought was PCP. And still this court can and should find that there is no reliable odor of PCP.
Oh, Counsel, let me ask you a question. Down below, as I looked, the defendant didn't put any proof on it, correct?
Correct.
And what do we have in the record regarding the smell of the substance?
There's very little. All that we have is Dorchester saying, I
He
smell this.
So
Yeah.
how can we make a determination? Are we supposed to Google and do our own research? Are we allowed to go outside the record? I mean, we're confined to the 4 corners of the record.
That's true. And so I think primarily my argument would be the people didn't make their case. This was the people's burden. They're asking this court to find for the first time that the odor of PCP constitute probable cause.
Yeah, but Counsel, as pointed out by my colleague, Justice Niemeyer, there's other courts have found you can smell PCP.
Only the First Department in New York.
Okay, so you want us to find as a matter of law, without any expert testimony, that you can't smell it's impossible to smell the odor of PCP. Even though, didn't this officer testify that based upon his experience and training, he knows and he can detect the smell?
He said it's a pretty distinct smell, although he acknowledged that there are other things in the world that might smell like it. So that's our first argument, that this court can just find that PCP can never constitute probable cause. But that really is not even a necessary decision for this court.
Counsel and Darby, when they decided the other way, there was proof put on by the defendant about the ability to smell. And in Darby, there was even an argument that the PCP was in 2 separate plastic bags that would make it difficult to smell. None of that is before this court.
That's true, because the people didn't put on their case. I mean, there was a lot more in Darby, and the court had more to work with when making this decision. Here, the people just put on.
Counsel, not to cut you off, but and I understand where you're going from, but you keep on saying that people had the case. They put on a case with an officer with experience that says, I smelled PCP. That's their case. So what more are they supposed to do? They're supposed to bring a chemist in every time they do it. He says, I've been trained in it. I smelled it. It was there. And that's what he did. And you're saying it's their obligation to do what? And Darby, as my colleague pointed out, and Darby, the defense on it was, you can't smell it. And that's where that's where we have there. So I don't follow your argument that they have the obligation to put a case on, because I think they did put a case on.
So you would have to establish below, in my mind, either that as a matter of law, that it's impossible to detect the smell of PCP, or you would have to have an expert come in, wouldn't you, to say that that's the case. And then we could determine whether we were willing to go as far as to say as a matter of law, or secondly, whether we would be willing to say that the court made a misstep or erred when they adopted the testimony and found that the officer was credible over your testimony. But that's not what we have here, is it?
It's not. And I guess two things. First of all, I think if this court affirms this decision, this is going to set a precedent that's going to have potentially wide-ranging implications in this department, that from now on, the smell of PCP can constitute probable cause. So just because this particular defense attorney didn't put on that evidence.
No. That's based upon the facts that are brought out at the hearing, the expertise of the officer, their exposure, the credibility, and what they smelled and how they smelled will always be subject to it. What this case would be saying is that we want us to say that it's as Justice Carney pointed out, that as a matter of law, it can never be because it's an odorless. And they talk about the difference between, which I thought was interesting, difference between street and what they call it, street and pure PCP. And that's what some of the cases and stuff you had in your brief. And so,
right.
We Counselor, what we did was, and this is not directly on point, but indirectly years ago, we were wrestling with the idea of unburnt marijuana, that the police officers would say, hey, we went in there and I smelt the unburnt marijuana. And in my mind, the issue is this, is whether or not, as a matter of law, this court or another equal court or the Court of Appeals has decided that as a matter of law, PCP is odorless. Therefore, it can't be the basis of the probable cause or the determination that there's some drugs in the car. Or in the alternative, you would establish that, like I said earlier, by way of bringing in people, that know this stuff better than we do, and establish a record that says PCP is odorless, and therefore, it can't be the foundation for that. Now, and I have to tell you, I know that we're a little bit concerned about how you cast your arguments about what took place here. We're lawyers and we're judges, and there's an easier way to say things sometimes. For example, that person's not credible, or the court shouldn't have found the officer credible, versus an out and out lie. I think that's what one of our concerns is. And so maybe you have something here. I don't know, but I think your argument, if I understand your argument today, you want us to determine that as a matter of law, PCP is odorless, and therefore the court couldn't have got where they got. Is that correct?
That is one of our arguments, but I think our primary argument is that the people didn't prove their case that it does have an odor. And I understand that the officer did testify that odor is familiar to myself as PCP, but this wasn't even a drug recognition expert. It was just an officer who just said, I've seen it in the field.
Okay, so what you're saying to us is this, as you're saying to us, is that there was an improper foundation in order to qualify this individual to have smelt PCP. That's really what you're saying to us, because you're basically saying now that he wasn't this, he wasn't that, he wasn't a drug expert, but yet he's testified on the record, under oath, under cross-examination of his experience, and he smelled. So it's a credibility determination on whether or not the court believed there's a sufficient basis for him to make that determination.
For a lack of foundation.
Right. I mean, certainly he could give his testimony about his observations and his experience, but more was needed before the court could.
And so your issues with the foundation, counsel.
Yes.
It has to be. I mean, right? That's what you're saying.
Correct. That he alone was not enough to.
I think we have your argument.
Because we don't know. I don't know if PCP smells or doesn't smell, or has an odor or doesn't have an odor. I have no idea. We base it upon how the proof comes in.
Right. And here the proof was very, very limited. And just as one final point, the Court of Appeals has said many times, that if an observation is susceptible of an innocent as well as culpable interpretation, then it can't be probable cause.
And we looked at those cases where it could be an element that makes the drug, but it's not the drug itself. I'm familiar with the line of cases.
Okay, thank you.
Counselor?
Good morning, Your Honors, and may it please the court, Jessica Carbone for the people. Your Honors, counsel repeatedly asserted that the people did not meet their burden at the suppression hearing. And Judge Century, you touched on this a bit in your comments. The burden at the hearing, if you looked at defendant's papers, was to discuss the nature and the quality of the odor. And that's simply not the burden, Your Honors. That language comes from the hearing court determination in Darby. And in fact, the First Department in its decision explicitly rejected that. The First Department held that making the people prove the nature and the quality of the odor would, quote, constitute an unnecessary waste of time. The First Department held, and as we set forth in our brief, that the burden is simply that the people establish that a witness is qualified in experience and training to detect the odor, and that he did detect such odor. Your Honors, there's nothing in this record which would render the hearing court's determination with respect to Officer Dorchester's credibility or qualifications erroneous. And if Your Honors have no questions, I would rest on my brief.
Having none, counselors, thank you very much.
Thank you.
232, People v. Laura. Good morning, counselors.
Morning, Justice Sentra, and may it please the court. I represent Ms. Laura. The evidence in this case was legally insufficient to support Ms. Laura's convictions for kidnapping in the second degree as an accomplice. In particular, the people failed to prove a coinciding mens rea and actus reus. That is to say, the people failed to prove that when Ms. Laura brought food, the Little Caesars pizza, to the Harvest Street residence, she was even aware of the kidnapping. Similarly, they failed to prove that when Ms. Laura arrived at the house and ultimately figured out what was going on in the house, that there was something nefarious, that she engaged in conduct that furthered the kidnappings. The people conceded on summation and seem to acknowledge now on appeal that they had failed to prove that when Ms. Laura arrived at the Harvest Street residence and brought the pizza, that she was even aware of the kidnappings. Indeed, the Facebook messages between Ms. Laura and the ringleader in this case, Perez, failed to show a guilty knowledge on the part of Ms. Laura. Indeed, that's what the people acknowledged on summation.
Counsel, let's do this. Let's focus for the one part. I understand your argument. On the one part on Mark's Pizza, it's a Mark Pizzeria?
Yes.
Case, okay. You know, they have an argument here they're making is that they can string together and reasonably infer that she left the house to go get the Mark's Pizzeria. And when we look at the proof or testimony involving that, we have to look at what light most favorable to the people, and then considering, is there a valid line of reasoning and permissible inferences that support the conclusion that they had the let's say the shared community intent, that the jury could come to that conclusion. So that's really the focal point of the second portion of the food.
That's correct. That's the people's argument now. They've narrowed it down that at approximately 8:30, Ms. Laura left the residence for purposes of picking up the Mark's Pizzeria pizza. But I would submit that is entirely conjecture. What is this argument based on? It's based on merely the fact that approximately an hour before Ms. Laura left at 8:20, that an order of pizza had been made, that the pizza was never picked up, and that the individual in the driveway that was blocking her in ultimately parked on the street after she left. There was no proof that Ms. Laura was ever told that there was an order of pizza. There was no proof that she was ever.
We also have, as you know, one of the co-defendants ordered it, left his cell number, and also he left the house by way of foot.
That is correct, but
I'm just saying, I understand. I'm not saying that's significant enough. I'm just saying to you that, you know, when we take a look at this case, and like I said, I think you have a good argument here. We look at whether or not we can string together those types of evidence and conduct in order for a jury to reasonably conclude with a valid line of reasoning.
Of course.
That's where it becomes a little more difficult.
Importantly, however, there was no evidence that Ms. Laura was even told that an order of pizza had been made. She was never told of that fact. Also importantly, she told no one that when she left at approximately 8:30 where she was headed. And probably one of the most significant.
But there is a suggestion that the passenger she arrived with stayed at the house, and therefore at least the jury could make a reasonable assumption that your client was coming back for her passenger after she picked up the pizza.
That would be speculation. I mean, there are many reasons why her passenger wanted to stay. As you recall, this was a party. There were people coming and going all evening. It was Monday Night Football. People were smoking marijuana. They were drinking. There were all sorts of reasons, including perhaps that the co-defendant was attracted to Pretty Boy, the ringleader of this operation. And then talking about Pretty Boy, there's a significant point that must be made. Remember that Perez, the ringleader of the operation, sent a Facebook message to Ms. Laura approximately 2 minutes after she left, asking, "Yo, what are you doing? WYD." If Perez, the ringleader, didn't know where Ms. Laura was headed, how on earth could the jury conclude based on evidence where Ms. Laura was headed? Secondly, Justin
Perez wasn't the one who ordered the pizza or left his number, isn't that right?
That is correct, but there's no evidence that Ms. Laura had any communication with this co-defendant, Alcarez Ubiles, who Justice Nemor you're referring to. There was no evidence of any discussion about the pizza. Zero.
But as you recognize, Counselor, sometimes, and you know there doesn't need to be a discussion. I mean, we can look at the evidence and the conduct of what took place and whether or not those factors reasonably conclude. Like I said earlier, I think you have a strong argument here, a good argument. The question becomes is, what are the facts before us? And you've pointed out a number of and I don't think they're fatal, but a number of relative good questions in the sense of what was lacking. So the question is, after we put everything on a board and we take away what was lacking, then we look at what we still have and whether or not that meets the standard.
There's another point, though. Let's assume she did leave to go pick up the pizza. So what? She never did pick up the pizza. You know, intentions, whether they're good or bad, are never enough for accomplice liability. There has to be an actus reus. There has to be an act of assistance.
So your argument is that her act of going to get it and she never makes it there, it absolves her of the crime. Even though she didn't. So let's just assume, for argument's sake, what you're making here, she's told, go get his pizza, and she says, okay. Let's just say so what you're saying here, if they told her, go get the pizza, we can't leave the house, go get the pizza, and she gets in the car to go to get the pizza, and on the way, she gets in an accident.
I am saying that intentions alone are not enough to be guilty as an accomplice.
I asked you a question.
And the answer is, unless there's an act of assistance, and there has to be a completed act of assistance for.
That's the key word you're relying on. You're relying upon your view of the completed act of assistance is actually the act of picking up the pizza, as opposed to the act of going to get the pizza. Right?
Otherwise, she has not aided the kidnapping. She has not furthered it in any way. So that's a critical point here. So again, intentions alone are not enough. There has to be, under Section 20, an act of assistance. So And if that is their sole theory to uphold this conviction, it fails.
Okay, what about the weapons?
Well, I would rely on our brief with respect to the weapons conviction, other than to say that the evidence against Ms. Laura was no stronger than it was against her co-defendant, in which case those convictions can't stand either.
Thank you, Counselor.
Right, thank you.
It's great.
Morning, Your Honors. Lisa Gray for the people. May it please the court. I just want to be clear about something. This was not a party. It was a gruesome kidnapping that had taken place over the course of almost 48 hours. So Miss Laura's participation in these horrible events, she joined that kidnapping that was in progress. She formed an intent that it be successfully completed. And I want to back
How long was she there before she purportedly went to get the pizza?
She and her co-defendant, Miss Roldan, arrive around 6:25 or 6:30 on Sunday evening. She leaves the house around 8:22, 8:25 to go get the pizza. But more importantly than that, if you look at the text messages between Miss Laura and Miss Roldan, you'll see that as early as about 7 p.m. that evening, she has realized that there are captives in that small house on Harvest Street. She has realized that there's criminal activity going on. She clearly has romantic interest in Dennis Perez, so she's going to do what she can to hang out with him, to spend time with him. And not only that, she actively assists in this kidnapping by telling Miss Roldan to use fake names so that they shield the identity of Dennis Perez from the two people who are being held captive against their will in that small bedroom off the living room in that house on Harvest Street. And I think that is really compelling evidence, the fact that she actively assisted. We know from the evidence adduced at trial that the kidnappers were going to keep those two victims in the house alive, at least until Monday morning when the banks reopened, so that they could have the one victim make phone calls to the banks to move around money or withdraw money. So at that point, in that small house at 7 p.m. on Sunday evening, Miss Laura actively says to her co-defendant, hey, don't call him Dennis. He's Rico. Refer to him as Rico. I'm editorializing a little bit. You can look at the text messages. She does that specifically to shield his identity from those captives so they can't say anything the next morning. I think those are logical inferences that the jury made at the time of the verdict. There's legally sufficient evidence to support the fact that she actively assisted and aided those kidnappers in this gruesome crime. With respect to the pizza, she leaves the house at around 8:30 or so. She starts her car, she backs up, she drives up the street. She's actively assisting in getting more food for Dennis or for the other.
How do you address the counselor's question, the fact that she, by leaving the house and going to get the pizza, let's just assume that those set of facts, the fact that she never made it there, the fact that she never got the pizza, therefore she never.
Excuse me. I don't think she had to complete the act of walking into Mark's Pizzeria and picking up that pizza. The fact is that she was doing it so Dennis Perez or David Alcaraz Ubiles didn't have to leave the house. They didn't have to leave their captives. By her going, at least attempting and actively assisting in going to get that pizza, she perpetuated the hostage situation. So she, and the police officers intercepted her. Thankfully, the police officers at that point were investigating and had narrowed down where these two victims were being held, and she was taken into police custody. But she completed whatever active assistance was required of her by getting in that car and starting down the street so that her two co-defendants didn't have to leave those two captives unattended. Unless there are any other questions, I would rely on our brief and that there is legally sufficient evidence to support the kidnapping and the firearms related convictions.
Okay, thank you, Counsel.
Thank you.
233 People v. Graham. Good morning, counselors.
Good morning, Your Honor. May it please the court, Phil Rothschild for Clifford Graham on behalf from Hiscock Legal Aid on behalf of Clifford Graham. In the first trial, Mr. Graham was acquitted by the jury of the assault charges, unlawful imprisonment, menacing, and a host of other charges, because basically the jury did not believe anything that the complainant had to say. And the only reason he was convicted upon the weapons charges because the trial court failed to give an temporary innocent possession charges, this court ruled. As bad as that trial was, this was worse. First, regarding the grand jury, there were a number of problems. The first of which was the collateral estoppel, double jeopardy, Fifth Amendment, whatever you care to call it. There were the same parties, the same issues, and the prosecutor clearly had the opportunity to litigate. Yet they decided to, and I don't know why, but this Justice Nimoy talked about there being rules, and there are rules, and the prosecutor should have known that they should not have introduced evidence regarding.
Okay, counsel, let's just assume this. Let's assume you're correct on the collateral stop. They shouldn't have been able to put it in grand jury. Do we have any potential prejudice? Don't we have to show that next level in order for on the indictment?
I think
Yeah,
there's
to establish it was defective and the integrity of it is impaired. It's a pretty high standard, isn't it, Mr. Rothschild? So tell us.
It is a high standard, but I believe that this is one that reaches it because, pure and simple, this was a case where there was not a whole heck of a lot of proof of the regarding the possession of the weapon, because they had to charge this temporary innocent possession, and the people attempted to say, well, it's inextricably intertwined, and it wasn't. The trial court said, look, this is absolutely irrelevant.
Excuse me. Is Justice Carney, and I asked Justice Carney followed up with, what you're saying it wasn't intertwined. The question to you is, assuming that it's collateral stop, assuming it wasn't.
Yeah.
You still have that hurdle. Yeah.
It shouldn't have been done. I get.
Absolutely. It absolutely should not have been done. And the evidence was incredibly prejudicial on pages 100 to 104 of the grand jury. Basically, she's testifying to things which are absolutely unnecessary, saying he hit me, he beat me, he pointed a gun at me. There was no reason for it. It served no purpose other than to inflame the grand jury for what was conceded, basically a very weak case. And we would point out the same rules of evidence apply.
Okay, so your argument is that without that proof, it's something you can be saying, without that proof, they shouldn't have come in, that there would have been no indictment?
I believe so, Your Honor, because of the paucity, the bare bones nature of the proof regarding the possession of the weapon. And moreover, I think this court should look at
bare bones, you have two witnesses, don't you?
Yes, and those witnesses essentially were at the first trial were absolutely devastated on cross-examination.
Yeah, but we're not talking about the first trial, or we're talking about the second trial. This is grand jury. There's a different standard. They're in the grand jury to witness. Eyewitnesses testify he's got a gun. So when you're saying to me that it affected the jury didn't know about how the cross-examination went on the first trial.
No, that is true, but it's the nature of the witnesses, and also Mr. Graham, I believe, also testified, and he said, I picked it up and this is what happened. And they didn't have a whole heck of I mean, it came down to what they said, and what they said essentially did not make sense, even looking at it in terms of grand jury, because it was pervasive repetition of improper matter, prejudice the defense, bolstered the weak case. And this was preserved. And I think the second grand jury error, I think, was even more apparent regarding the constructive possession charge. The only reason we learned about this was because the prosecutor attempted to get this charge at trial, and the judge said, that makes absolutely no sense whatsoever. And the prosecutor said, hey, we informed the grand jury about it. Clearly, this was not an attack on the sufficiency of the grand jury presentation.
Let me ask you this, Mr. Rothschild, getting back to this whole idea about the integrity and prejudice. There's no doubt that under either version at trial that your client admitted to having the gun at one time. The defense was the temporary innocent possession, right?
Yes, Your Honor.
Okay, so tell us how this constructive possession instruction affected, why it affected the grand jury proceeding to the point where your client was prejudiced.
Because the panel could have found, in fact, that he had possessed it constructively, which was not a proper basis for finding the indictment. as
In
the
other
trial
words, I
court.
mean, on its face, it sounds like it makes some sense to me. In other words, he's in the house and the gun's there, and that's the constructive possession. But he already admits to having the gun prior there too, right?
Yes, Your Honor. However, the jury may have found that, in fact, because he only possessed it temporarily, and I'm assuming that the temporary innocent possession charge was given in the grand jury. I don't know. I don't have those minutes.
Now, we know that.
But
We
they may have
understand.
found that they may have found that he still nevertheless possessed it constructively in the house, even though the
Yeah.
prosecutor's theory of the case was, hey, he doesn't live here, he doesn't own the premises, he has no control over the premises. And Judge Brunetti said, look, it makes no sense whatsoever, even under your version of the facts.
Yeah, a little
They-
inconsistent though, isn't it? In other words, I mean, I understand what you're saying. You're it's almost like an attenuation thing. Like maybe he constructively possessed it earlier, but then when he claims that she took the gun, put it in the bedroom, right? At that point, the grand jury could have indicted based upon his being in that room and the gun being nearby.
Absolutely, Your Honor.
Yeah, okay.
And the
I get
third
it.
point I'd like to raise is the shackling. I mean, this was addressed in the court below. I believe the real problem with this was the fact that when Mr. Graham asked to be unshackled, the court denied it. And they said, well, why not? And the court never gave any reason or justification for his shackling in the first place. And it said, well, they said a curative instruction was sufficient. That's not really the way we want to look at these things, because there has to be a reason in the first place for why the individual is shackled. And you just can't like go ahead with an eraser and say, oh, well, we gave a curative instruction, because there's a certain presumption of innocence which is undermined.
So what you're saying is the standard that is used in trial, because didn't the shackling take place in grand jury?
It took place in grand jury. That is the third grand jury error.
Yeah, so what you're saying though, basically, is that what the standard of review is, or standard takes place in a jury trial, with shackling should take place in the grand jury.
I think at a minimum, the trial court has an obligation to put its rationale in the record so this court can review.
Well,
And
isn't
none of
that what's required normally in a trial? The court has to.
I believe so. Yes. I mean, I did the Vigilante case, like 25 years ago, and the court found that that's absolutely required. You have to give a reason. You can't just defer it to whatever the deputies may think. The court has the obligation to, in fact, because it runs things, and with the grand jury, they has to give a reason for why this individual is being shackled, and none was given here.
Now you want to deal with the weight of the evidence and legal sufficiency?
Yes, Your Honor. As far as the weight of the evidence, this was, as I noted in my brief, the proof in this was incredibly thin. It depended upon the credibility of the complainant and her son, and defense in this case was really put at a disadvantage, because even though the proof was supposed to be limited, well, at least at trial, and obviously not in the grand jury, basically this presented dangers for defense counsel. He was not able to effectively cross-examine her, but there were still things that she said which made absolutely no sense. And the fact of this, finding the gun in a pink lady's purse. Now, the police were very hesitant to call it a pink lady's purse, but it was. Certainly, militates in favor of Mr. Graham's story. The bystander certainly militates. The fact that complainant couldn't tell the truth to save her life. She lied about her name to the grand jury. She said, well, I'm Miss Montana Brown, but at trial she said, I never said that.
Well, counsel, do you think the jail call recordings had any play at all, or any?
I think that it was not, as I indicated in my brief, it was not a smoking gun. I think basically Mr. Graham was incredibly frustrated about being prosecuted, which in this case, which I think he had every right to be, because this was a case really based upon, he was stupid. Let's be honest about this. He thought it was his girlfriend. He thought he had a relationship with her. He didn't. The person who made the call to the police, there's only one person it could have been, and that was Montana Brown. And the police never gave any reason why they were going to a quiet house where nothing was happening. They opened the door. She's fine. She doesn't have a mark on her, despite claiming, that he had beat her with both fists and a pistol.
Which he was acquitted of, right?
Which he's acquitted of. And it's basically, there's so much about this, it makes absolutely no sense whatsoever. The other thing I'd like to address is the refusal to read back the temporary innocent possession charge. That's why this case came back in the first place. The court has to provide a meaningful response when the jury asks them for instructions. And in this case, they asked about this because they clearly had problem with the possession of the gun. Now, when someone raises the temporary innocent possession charge, that essentially becomes an element of the crime because the people have to prove it or disprove it beyond a reasonable doubt. It wasn't done here. The jury was essentially left in the lurch, and the court's refusal, despite repeated requests, was we contend error that requires reversal. And as far as the sentence, you know, for these facts, giving 12 years, I mean, if this court doesn't reverse, I would submit that 7 years is absolutely proper based upon even what is alleged to have occurred here, even taking everything that he's convicted of.
Thank you,
And
Counsel.
other than that, I'd rely upon the brief.
Thank you. Mr.
Good
Olson.
morning, Your Honors. Brad Osler for the people. May it please the court. I'll address the grand jury issues first. I would submit, I think our papers lay out our position thoroughly, but the testimony of the victim before the grand jury about what the defendant did with the gun, essentially, that he hit her with it, that he, essentially menaced her with it, forced her into her apartment, kind of kept her there. Those being the charges that he was acquitted of in the first trial, I believe those are inextricably interwoven with the facts of the
Yeah, I
simple
think
possession.
you got a hard argument there, Counselor. I think I would stick to the standard.
Well, sure, and I'll let me just say one other point about that. I think the reason I make that argument in the first place is because to limit her testimony, to eliminate that, would be to force her to essentially say, yep, I saw him on this day and he had a gun, and that's it. And that's not reasonable. But to your point, Justice Carney, the grand jury wasn't fundamentally impaired by that testimony. And as I believe the panel pointed out, that's a relatively high standard. This is less than other cases that our office has argued where grand jury proceedings have been found to not be defective. The simple possession of the weapon was certainly proven by her testimony, and even if we view the rest of her testimony as somewhat extraneous, it didn't impair the grand jury's ability to vote a true bill. Certainly, the issue with respect to the constructive possession instruction that was provided to the grand jury. First of all, I'd submit that I think it was reasonable, given that when the police entered the bedroom of the home, the gun was not on defendant's person. So a simple, reasonable viewing of the facts would suggest that instruction should be read. The fact that the trial court later on decided that did not apply and should not be read to the Pettit jury, I don't believe that suggests that the grand jury proceeding was defective, because essentially the Pettit jury convicted on a narrower set of facts, a narrower set of instructions than the grand jury voted a bill on. And if there is a defect, which I'd submit there's not, I think it was somewhat shown to be irrelevant based upon the Pettit jury conviction. With respect to the weight of the evidence, I just note that the people's witnesses were very consistent in their testimony. The principal difference between the victim and her son's testimony was where or sort of how the defendant actually possessed the gun on his person, be it in his hand or his waistband. And I don't think it's reasonable to believe that he, during the course of 2 or 3 hours, held the gun in the exact same position the whole time. I do believe the jail calls are somewhat inculpatory. Defendant did not suggest that the victim needed to tell the truth. He said that she needed to forget what happened or get amnesia, something to that
Counselor,
effect. Yes.
The jury listening to that jail call could certainly view it as inculpatory and not the kind of statements that someone who was innocent of the charge might make.
Absolutely, absolutely. And I think is it proof of possession of a weapon itself? No, but it's certainly the type of extra evidence or corroborating evidence that suggests that the weight here is more than sufficient to sustain the verdict. And just very briefly with respect to the readback, the judge responded to the jury note, which simply requested essentially the elements of possession of a weapon, and it provided that instruction. I think it's very telling that the court specifically advised the jury, hey, if you would like the temporary innocent possession essentially the affirmative defense here. If you would like that read back, tell me and I will do so. And the jury chose not to.
Meaningful response.
Exactly. Certainly a meaningful response. Other than that, we'll rest on our papers.
Thank you, counsel.
Thank
Thank you both. 234, People v. Manners. Morning, Mr. Davidson.
Let me unmute.
Yeah, you got it. Okay, you got it.
I didn't realize until this morning that my opponent would be submitting. I'll be brief. I think this is a classic agency case. Mr. Manners was not the seller. His girlfriend calls him and asks him to set her up. The trial court refused to give the agency instruction, specifically because it believed it relied on the fact that he kept a portion of the cocaine for himself. The Court of Appeals said in Lam Lek Chong in 1978 and in Echevarria in 2013, the fact that the agent keeps something for himself in the nature of a tip.
Also, it's a little bit more than that. Here, the buyer calls him, asks for $50 worth. He tells her to meet him somewhere, says, I don't have crack, but I have $30 in Valium. She says, no, I want crack. He says, I'll see what I can do. He calls her back, changes the price to it now being 100, shows up at her place, says, I need the 100. He gives her the drugs, but takes a piece of it. So he gets paid at a price set in advance, and he takes a piece of it. This is hardly an agency where it's like, oh, thank you for getting me drugs. Here's a tip. I just don't see your argument.
Well, the case law, Valentin, I believe it is, or I'm sorry, it's Roche, says if there's evidence, however slight, in favor of the agency argument, then you've got to go to the jury. And
So the question really boils down for us to decide is whether or not that in and of itself, from the facts you've recited to what Justice Niemeyer, whether or not it was so slight that even with those facts present, that he took money, set the price, set the dollar amount, took the drugs, whether or not that in and of itself is sufficient, the slightness of it. That's really what it comes down to.
That's what it comes down to. But and I would point out that this wasn't like salesman-like behavior. They weren't dickering over the price. She said, "What's out there? I've got $50."
They were familiar. They were friends. They were drug buddies. They've done drugs together. It isn't stranger on stranger or dealer on druggie. It was more friend on friend is what your argument is. And that's why this fits more into the agency than it does to a drug sale.
That's my argument, Your Honor.
Thank you, counsel.
Thank you.
237, 238, matter of D'Angelo B. Counselor, you got to get off the mute. Okay, can you hear me?
Yes, thank you, Your Honors.
Before you begin, I have to point something out. Pursuant to the rules of the court, we send these issues out, or we send this out ahead of time. This is a court session, and because you're an attorney at law, correct?
Yes, Your Honor.
We expect the proper attire to be worn, and obviously you don't have a jacket.
I am sorry, Your Honor. I simply forgot.
No, I understand it, but I'd be remiss by not, because if someone, I'd be remiss by not at least pointing that out.
I appreciate it, Judge, and my apologies to the court. Like my last counsel, I was not aware there'd be a submission by the other party this morning, but I would like to address a couple of points briefly, because there does seem to be some confusion across the record in the different pleadings because of the lack of development of a good record for this at the trial level, because the criminal allegations were never really set forth in the in either the petition from the family court as to what the basis was or the like, but it is clear that there was a drug sale May 26th and a drug sale on June 13th. In the parallel case involving Tia K that's going to be heard on
Next term.
April 12th, it is in the record that that in fact, as the judge pointed out, that there was in fact a transaction on the 13th at which there was a call to the residence. The Tia and Gregory left the residence with drugs to do a sale at another location. The children were home. So this is pretty much clear what establishes this difference between the 13th and the 14th. So the 14th, the search of the home, is the execution of the search warrant based on the activities from May and from June 13th, the day before. In this case, trial counsel, in fact, withdrew the motion to dismiss based upon the allegations that are being set forth here as the evidence of innocence, so that he could consent to the neglect. Additionally, the neglect petition itself was broader than one single drug event. In fact, the consent was
So
to...
we understand that. We understand.
Okay, thank you, Your Honors. Now, the other point is the interest of justice exception to preservation rules. As the Court of Appeals has made clear, this isn't simply a meaningless technical barrier to review, but should be pretty strongly used that the issue had to be presented. In this case, as pointed out, the first two warnings really didn't apply because the disposition was an Article 6 disposition, not a placement in foster care or a placement under Article 10 of the Family Court Act. Additionally, the third element of the report remaining with the State Central Registry is relatively minor compared to what he ultimately pled to before this and was sentenced to 4 years in prison after this. So I respectfully, there's a few different issues which could be implicating this shall be vacated upon motion. And I would respectfully ask the court to follow its prior precedence of not granting 1051F relief when it was not moved for in the local court, instead being moved for under 1061. Let us develop a record below in the event that he provides a motion to vacate under 1051F. Provide the lower court an opportunity to review its actions in the case, cure its own error if necessary. Additionally, would give us the opportunity to gather facts or the circumstances to ensure a complete record for appellate review, including the lower court's reasoning and input on the case. For example, there may be prejudice to the petitioner that may warrant the defense.
We recognize those factors, counsel.
Thank you, Your Honor. I have nothing further and would otherwise rest on the brief.
Okay, thank you very much. Have a good day.
Thank you.
239, Christopher Becky v. Stacy Hamilton. On the second, we don't have everybody yet. Yes, we have everybody. Counsel, you may begin. We can't hear you. Okay, go ahead.
I represent Stacy Hamilton, and Ms. Hamilton is asking the court to reverse the trial court's decision against the weight of the evidence.
So this is strictly just a best interest case.
Correct, Your Honors.
So we were past a change of circumstances. So, okay, go ahead.
Thank you. I would point out to the court that the trial court was very specific in their decision. And one of the main issues is that the trial court pointed out a significant amount of red flags as it came to Mr. Becky, and somehow still came to the overarching decision that it was in the best interest of the child, Sophia, to remain in a Head Start program that she was unilaterally placed in by Mr. Becky from the age of 3 to 4. And I think most important to the totality of the circumstances, and when looking at the court's decision and how it's against the weight of the evidence, is that the court seemed to find ways around these significant red flags and characterized the parenting relationship as, quote, strained, when it was very clear that Miss Becky or Mr. Becky severely alienated Miss Hamilton out of Sophia's life and out of some very significant decisions.
You know, I think the court, it's interesting, we have sort of like two unperfect parents. We have two parents that both have issues. The court's faced with the issue. The court listens to all the testimony, and the court found some troubling factors with the father and how he handled the education and lack of communication with the mother. And the court also struggled with some of the mother's shortcomings. This was, I think, a difficult case for the court. The court outlined its reasons, and your issue really is how the court concluded the things in favor of the father as opposed to the appellant, your client, and that the best interest really is in your client's favor, and all the factors weighed, not all of them, but most of them weighed in your client's favor. And is that really, I mean, really what's it boils down to the court's interpretation and fact finding. We have to look at the record to see whether or not those findings of the court, which you're telling us, are not supported by the record.
That's correct, Justice Sentra. I do believe that the lower court erred, and the crux of the issue seems to be that the lower court awarded points in Mr. Becky's favor solely based on really centered around just one of the issues, where the totality of the issues really painted a very different story. And I'll just kind of touch upon some of the points brought out in the response briefs. I think that the priority argument made by counsel, both counsel, is kind of mischaracterized. And that argument really is based on that the 2016 order made by stipulated agreement should, that factor should kind of be looked at as almost controlling. And it was pointed out specifically that it shouldn't be disturbed unless there's extraordinary circumstances. And one of the things that we look at in a situation like this is whether or not one of the parents has either become completely unfit or less fit than the other. And I would posit to the court that Mr. Becky became less fit, and particularly, I think, unfit, given what was brought out through testimony and evidence, and specifically documents he placed into evidence. Some of the extraordinary unfitness factors of Mr. Becky were that he instigated numerous occasions in front of the child that required police assistance, the child crying and becoming upset. Specifically, he instigated a fist fight between his girlfriend at the time, which was the second girlfriend in a set of very limited months, in front of the child. And that he then tossed Sophia into his car and went to go join the fight, and then yanked the maternal grandmother's hair.
Well, let's be fair. I mean, that's your version. Version was she was on top of his girlfriend, and he was pummeling her. She was pummeling her, and he pulled her away. I mean, we have testimony from all four parties that were involved in the fight. Who pushed who first? Who punched who had a bloody nose? I mean, I understand those factors, and the court was faced, as I said earlier, with making a credibility determination. And I think the court may have determined that maybe the girlfriend was the one who may have instigated ultimately for comments to start the fight. But once again, totality of what we have to look at is whether or not the court had a sound and substantial basis in the record on the best interest. And that's something we have to look at. And we look at all family court cases as to how the court came to its conclusion. Like I said, this isn't, in my view, quite honestly, this isn't a clear-cut case. We have a great parent and an unfit parent. I think we're stuck between two parents that love the child, I believe, from reading the record, but who is more fit at this point, or should I say, where's the best interest lie for the child? And that's what the court made a determination.
Yes, Judge, and based on all the points in the brief, it's Ms. Hamilton's position that the court made the wrong decision based on the totality of the circumstances. All of the other points that are made by counsel in their response briefs are fully briefed in Ms. Hamilton's brief. If the court doesn't have any further specific questions regarding any of these circumstances of unfitness by Mr. Becky, I would rest on my brief.
Thank you, Counsel. Counsel?
If it pleases the court, Your Honor, initially there is some element of modification regarding this matter in the initial custody.
We reckon with the time where we're familiar with modifications dealing with the visitation in the summers, and we're familiar with that.
Right, but the existing order also indicated that Mr. Becky was the parent for school purposes. And to correct counsel, the child was 4 when the Head Start program started, not 3 years old. She was 4 years old at that time.
Counsel, let's call it the way it is. We have 2 parents here. The problem we have with your client is he makes a unilateral decision on school that ultimately blocks the mother of the child from seeing him for that week. He did that on his own. And let's be honest, he had a DWI. He doesn't tell the court or the side. He drove without a license with the child in the car. As I said earlier, we have a situation where the court was faced with, in my view, two unperfect parents. And the court went with your client on the best interest analysis. And that's
Your Honor, excuse me. My client did testify that he did discuss schooling with the mother and believed that she had acquiesced. That's in the record.
The court didn't buy it. The court didn't buy it. He might have said it, but the court didn't buy it. You want us to agree with the court, and yet you're saying, well, the court was wrong on that.
No, Your Honor.
Buy it.
And again, mom had enough red flags herself, pulling out a carbon monoxide detector because it was beeping with the batteries. No proof of mental health treatment as was required in the initial order. No proof of her income, no driver's license herself. And frankly, Your Honor, these parties co-parented fine for 3 years. So the allegations that my client somehow bullied her into this decision is just not true. 4 years old, it was a reasonable time for this child to begin school. And again, the Judge Carney had the opportunity to review the credibility and the demeanor of the witnesses. We would ask that you give appropriate weight to that determination and allow the decision to stand.
Thank you, Counsel.
You're welcome.
Good morning.
Good morning, Your Honors. Jessica Vesper, attorney for the child. As the court correctly pointed out, I believe that you really hit the nail on the head with this case and so many others in family court that we're really dealing with 2 unperfect parents. And the court is put in a difficult position of making a decision as to who is better suited to provide for the child's needs. It is my position on behalf of my client that the court did correctly consider all of the factors, and after hearing the evidence and being in the best position to determine the credibility of the witnesses, found that the evidence favored respondent father. His home was considered, his putting the child in school and the guidance that he provided, the finances were considered, siblings were considered, as well as my client's position. And based on that, the court made the decision that Mr. Becky should have been the residential parent, and I support the court's position on behalf of my client. And if there's nothing further, Your Honors, then I would rest on my brief as well.
Counsel, I'd like to thank you very much for today. Have a good day. Thank you.
Thank you.
240 Kirk, MB, Rachel S. Okay, good morning. Everyone's present. Mr. Zucker.
Good morning, Your Honors. David Zucker on behalf of the appellant responded. Your Honors, the court below clearly erred by ordering a genetic.
Mr. Zucker, let me help you out a little bit here.
Sure.
As I understand your argument, the court got it right the first time in the May 4th, 2020 decision when it said that the marital presumption is not absolute and it triggers a hearing to address the best interest. And your argument is that's what should have been done here, at the very least pursuant to 532 of the Family Court Act, that before the genetic marker testing should have been done, there has to be a hearing based upon the presumption of legitimacy with marriage.
Correct, Your Honors. And specifically, there was evidence before the lower court on petitioner appellant or respondent appellant's motion to dismiss, wherein before the lower court was submitted a valid certificate of marriage, along with an affidavit from both the husband and the wife saying that there was not, that they never had, were apart for so long that they didn't have access to one another. And in fact, there was access.
That was the foundation, at least the argument as relates to the presumption of legitimacy, whether or not the petition alleged that the husband.
Correct, Your Honor.
Lacked access or not.
Correct, 100% correct, Your Honor. I also want to say that I've reviewed the opposition brief here, and the case chiefly relied upon by the opposition here, which is matter of Marlene, helps them not at all. In fact, that case specifically states, it's a Second Department 2011 case, specifically states that if you're going to raise issues, if you've legitimately raised issues of equitable estoppel, that triggers a hearing. In that case, the hearing was denied because they said there was insufficient facts to trigger equitable estoppel. That's not true in my case.
No, this petition was filed during the pregnancy, right?
Correct. It was filed before the birth of the child, and there was an amended petition filed after the birth of the child, simply adding the child's name, but no other different factual allegations. The amended petition did not allege that the mom was married at the time the child was conceived. And that was the basis for my motion to dismiss, because this child was born into a lawful marriage. The presumption of legitimacy is one of the strongest presumptions known at law.
Yeah, no, we're familiar with the case and the law.
Of course, Your Honor.
I'm very familiar with the case because, as the attorneys know, you were before me with an order to show cause. So,
yes, I was, Your Honor. Yes, I was.
Is there anything else that you want?
Nothing further, Your Honor. I would, for the rest of the arguments, if the judges have no questions, I would rely on the arguments raised in my brief.
Thank you, Counsel.
Thank you, Your Honor.
Mr. Keene.
The unmute button finally got me. I've been doing so well all this time. Justice Carney, yes, there was a May 4th decision, but after that decision, there was proceedings. And at those proceedings, on 3 separate occasions, family court provided appellant's counsel with an opportunity to explain what the harm would be to the child to ordering this DNA test. And on those 3 separate occasions, appellant's counsel elected not to answer that question. To the attorney for the child's credit, she did at one point. She was concerned about the child's comfort. But again, you know, that is not.
But counsel, when we have a situation here where once the presumption of legitimacy is there in a best interest analysis, you seem to say that there's a further burden that they have to come forward and say, it would seem to me the best interest of the child, the hearing, would be done during the hearing. That's how that's how the next step goes. And it seems to me that unfortunately it missed there, and you seem to rely, at least in the brief, partly thereof, that the record sufficient for us. But maybe something took place, and you're right. Maybe something took place before the court that we're unaware of. But on this record, how are we supposed to make a determination that there was sufficient facts before the court?
Yeah, why did the court change its decision? You know, in other words, I'm trying to understand your argument. Is your argument either that the argument relative to whether the husband was alone with the respondent, at all, during the relevant period? Or is the argument that there were enough facts here to determine the best interest of the child short of a hearing?
I think it can be both on that, Justice Carney. And I think to Justice Sentra's question as well, is why family court changed its mind here, I think, is because of COVID.
Yeah, I gathered that.
This is a child that a petitioner tried before the child was born. If this court takes this back to a hearing, we're talking about a child that's going to be maybe over 2 years old. And then we have a potential equitable estoppel argument created because of COVID and because of the pandemic. This father did everything right.
Well, I don't know. That estoppel is going to be a situation. He's continued to pursue this. He's not sat on his rights. So I don't see where equitable estoppel will come in no matter what our decision is.
So I think
so what you're saying to us is, based upon the special circumstances of COVID, that we should carve out an exception to what the case law clearly says about once you have a presumption of legitimacy and a best interest hearing.
I think there should be an exception, and you do have nothing in Family Court 532 says that there has to be a hearing. I think that
there's got to be facts before the court, no?
But I think that there are facts there, and the court gave the attorney for the appellant an opportunity to present.
Yeah, but the statute does say that no such touch shall be ordered, however, upon a written finding by the court that it's not in the best interest, under this situation. So, I mean, I don't know how the court's going to do a written finding. Sometimes we have situations where the court, the judge is familiar with the parties with, typical family court matters, Article 6s, et cetera. And very rarely do we say, well, you really didn't need to take proof. But, this is a different situation. I get, one of your points that, if a lower court errs and then by the time it gets to us and then by the time it gets back, that time is, I guess, not beneficial to you. That's
absolutely the case.
There's nothing, I'm not sure there's much we could do about that. And I wrestled with that when you folks came before me not too long ago. This thing moved pretty quickly, but I understand your point. The time between then and now, the child and the husband of the respondent are probably forming some type of relationship. So
absolutely.
Okay, I think we have your argument. Thank you, Mr.
Thank you, Your Honor.
Ms. Doctor?
May it please the court, I'm Karen Doctor. I'm Lily Renee's lawyer. First, I want to let everybody know that she is over a year old now, by a month or so. I met with her on February 11th. She is in the 97th percentile for health and weight. She vocalizes, she claps, she dances, she looks at books, she is walking. She, from my analysis, is on point developmentally for a young lady of her age, both cognitively and physically. And she was clean and appropriately dressed for playing with her lawyer, and it was good. And I was quite pleased with her development. That being said, I want to both rely on my brief and emphasize for this court that we needed to have clear and convincing evidence. And such things can only happen when we have a fact-finding hearing, when the court can assess the credibility of the witnesses, when we can all look at documents, examine, cross-examine, all of those things that the court should do in order to make an informed decision on the two-step process. The first part being whether the genetic testing should be ordered, and then whether it is in Lily's best interests. that issuance of the test would be appropriate. And we needed to have, uh-oh, excuse me, that's not you. I kept it on just in case this thing winked off. Oh, brother. That we needed to be able to have testimony for both of those pieces, and however it came out would be how it came out. But we needed to have findings on Lily's behalf. Other than that, if there are no questions, I will rest upon what I wrote. Thank you.
Thank you all today.
Thank you, Your Honors.
Thank you.
Everybody take good care.
You too, okay. 243, William Clements v. Thomas Miller.
even talking about 9180.
I think the point she's pointing out is that maybe the fact that it is that you're raising he's continued able to work and do his normal chores every day, therefore wouldn't qualify for 90 out of 180, but it sure doesn't make it not equal that because of that he doesn't have a qualifying injury.
Right, but we are not discussing 9180. What we're discussing is any sort of limitations he might have going forward through the present day. And as of the date of his deposition, which was years beyond the accident date, he was still able to feed the horses regularly. He was still able to muck out his stalls, perform all of his farrier work.
My understanding is the function of what is this? His foot.
Yes, his left foot.
Left foot. My understanding of his left foot dropping is that, yeah, he may not have pain, he may not have the aches, but it still doesn't function properly.
That is
Doctor recognized that he did have the foot drop.
That is the allegation, certainly, Your Honors, but he still does not have any of the limitations as admitted in his deposition testimony. So that would be our primary point on that. To the extent that there would be left foot drop symptoms, or that there would be some sort of actual objective medical evidence of an injury, we still did point out to the court, and this is a critical point, that the plaintiff admittedly, not only in his medical records, but admittedly had previously broken his left ankle. He had previously experienced left foot drop symptoms up to and including just 6 months prior to the accident. It's well documented in his medical record.
He also then explains, doesn't he, that he had gotten over that and in fact did his therapy, did whatever it took, and he no longer had that at the time of the accident. Now, that may not, appeal to the jury. They may think that it never ended, but he did in fact say that it did end.
Well, he claims that, but then also claims that he never had it at all. So I don't think he can have it both ways when his doctor is disregarding or denying entirely any pre-existing injury when there clearly was. And what we did show is both medical records and deposition testimony, along with Dr. Knapp's IME, showing that there was pre-existing injuries, that the plaintiff admitted it to Dr. Knapp during the IME, that there were medical records showing it, and that there were medical records just 6 months prior to this accident where the plaintiff admitted to his own doctor that he had left foot drop symptomology. So he, even viewing the facts most favorable to the plaintiff, he still has to acknowledge those. And he did not in the court below, and he still argued that they did not exist in the opposition brief that's before the court. So in the absence of any sort of explanation as to why the pre-existing injuries were different from the alleged injuries in this accident, the court should have, in the court below or here, should have credited that the defendants established a lack of causation. The plaintiffs failed to raise the question of fact. So our two main arguments are the deposition testimony bears out a lack of limitations irrespective of what the injury is. And number two, even if there was objective medical evidence of injury, that we have destroyed causation effectively by submitting the medical records, the IME, and the deposition testimony admitting to pre-existing where none has been argued in opposition and in fact has been denied. So those are the two points that we would rely on in arguing for reversal. As for the IME point, Judge Bannister, I just want to quickly revisit that point. I recognize that the IME does not have numeric percentage comparisons. He does use, Dr. Knapp does use a qualitative descriptions by saying there's slight reductions in plantar flexion, things like that. He doesn't use numeric percentage. I would just admit that he uses qualitative descriptors, which is sufficient. For those reasons, Your Honors, I would request reversal on summary judgment with respect to serious injury. I'll just briefly go through the issue of negligence. Your Honors, in the court below, the case, the trial court relied on a police accident report. They shouldn't have. It was in error. Police accident reports are
Okay, let's put that aside. Let's put the accident report aside. Isn't there still negligence per se here, or as a matter of law, that your guy backed up into somebody who he didn't see, who was in fact there?
There is not, Your Honor, and it's because when viewing the facts in the light most favorable to my client, who's the non-moving party on this issue, he did everything that he was supposed to do or could do. He stopped. He had his four-way flashers on. He has an orange triangle on the back of his large water tank on a tractor. He's on a country road.
He did all that. He did all those things, but yet he backed into the plaintiff. Okay.
I mean, Counselor, don't we really focus in on is Justice Bannister asking, he backed up, he hit him. There's no dispute. The question then becomes, is there a non-negligible explanation of the accident? I mean, it was there to be seen. He didn't see him. He backed up and he hit him. And if you look at the vehicle and traffic law, as Justice Bannister pointed out, that's a violation.
Absolutely. But there's also case law with, Your Honors, compare this to like a tractor trailer, a semi that's backing up. It has blind spots right behind it.
But your client admits he didn't even turn around. He just presumed that nobody was on that road because it wasn't a very well-traveled road. And he just backed up without even turning around. Yeah, I didn't see any testimony from him that, well, I craned out of my seat and tried to look around the best I could see. He just says, well, there's a space behind me I can't see. I presume nobody was there and I backed up. Well, he was wrong.
Well, Judge Niemoyer, in that type of tractor, he's got a mirror here. He's got a mirror to either side that's able to look out, much like a tractor trailer, coning out either side. He cannot see directly behind him because he has this large water tank. So he cannot.
There's a blind spot behind him that he couldn't see, and yet he still backed up. I mean, he could have went up the road and turned around, but he backed up. He chose to back up instead. And lo and behold, he hits the plaintiff who was there.
Of course, Your Honor, but he could not see only a limited distance behind.
I know, Counsel, it's a difficult argument to make because what you have here.
Your Honors, I would just close by saying, viewing the facts in the light most favorable to the plaintiff or to the defendant on the issue of negligence, that there's at least a question as to whether the plaintiff may have been the sole proximate cause, especially where he has contradictory testimony. We've fleshed it out thoroughly in our brief. I think his testimony regarding the speed of a tractor is impossible, that it could possibly go 35 miles an hour. On that basis, I believe summary judgment on the issue of negligence should have been denied. I'll rely on the balance of my papers. Your Honors, thank you very much. I'll rest.
Fair enough, Counsel. Thank you very much. Counsel?
Good morning, Your Honors. If it please the court, Mark Cambreri from Sobo and Sobo for the plaintiff respondent. This is my first time in front of the fourth department. I've been in front of the second and third department numerous times. I'm very honored. Thank you. Thank you. So I'll address, they didn't meet their initial burden of proof. I'll discuss causation first. They say in the reply brief, well, first of all, let me strike that. First of all, they submitted no medical records in their initial papers. They only submitted the IME and the deposition. Now in the deposition, they ask him plainly, do you remember telling Dr. Dalton in January of 2016, so before the accident, you were experiencing left-sided foot drop? No, I do not. Now the subsequent questions don't then go back in time. They go, do you remember telling him that you're achy? Yes. Do you remember telling him something happened from time to time? Yes. Pause, pause, pause. Do you remember telling him that you had lumbar stenosis, left foot drop, and that you tolerate pretty well and you didn't want surgical intervention? Now, there's no time parameter to that question. So at any given point in time, do you remember telling Dr. Dalton about the stenosis and that you didn't want surgical intervention? I probably said that, yes. So there's no evidence in the testimony that there was some prior left foot drop and that was treated. All right, it's just not there. Also, in the IME report, the doctor discusses medical records, but when it comes to this, he doesn't say he read the report. He says he was described as having a previous left foot drop from a visit with Dr. Dalton. So he doesn't say, oh, I read this report and it says this. He says he was described as having. That's not meeting your burden of proof with causation. So There's no evidence of prior medical treatment. And the only case they cite.
Counsel, if they met their burden, you argue that you raised a factual question. Does it matter to us if we say, assuming Wendell, they met their burden, you raised a factual question? It's the same result as far as you're concerned, isn't it?
Yes, that would be true. Yeah, because even then I have causation based upon an affirmation from my physician as well as his report, which was based upon a thorough review of the medical records.
And more importantly, you have your day in court, a trial.
No, I don't think so because of the COVID, and we've tried resolving this. I think the appeal was made for purposes of delaying the trial, so you'd probably seek a stay. But COVID happened, and now it's even further delayed. My client is 71 years old presently, and as described earlier, he was retired 23 years, 7 months as a Navy medical corpsman, retired to a horse farm. Very nice. So he's enjoying his horses. So what do you wear when you're a farrier or you're on a horse farm? You wear cowboy boots. You wear boots with a heel and a hard toe that fit inside the stirrup and don't get loose, and so that you can ride the horse. And the boots go up to below the knee, so he doesn't need to wear a brace if he's wearing these boots. And he said that in his testimony. So that's why most of the time he can get along with that and do his activities and enjoy his retirement for the most part.
Counsel, can you address the negligence issue?
Yes, Your Honor. There's no question that he violated VTL 1212 by backing up without looking, but it was not reasonably safe to do so. I would add, though, that there's no comparative fault on the part of my client. He was faced with an emergency, not of his own making. It was a man-made.
Counsel, but we're not there yet, are we? We're not there yet with regard to the, whether or not the plaintiff contributed to the causing this accident, right? I mean, we will face that another day. That wasn't part of the decision of the court.
That's correct. It wasn't. I just
well, this is strictly Rodriguez. I mean, do we have a situation here where the defendant was negligent, and as Justice Bannister mentioned, at a later date, if we determine he was, affirm it, then ultimately it doesn't. You can address the issue whether or not there's a comparative component down below or lack thereof.
Very good, Your Honor.
So I think we have your argument. Thank you, Counsel.
Thank you, Your Honors.
Thank you both.
Thank you, Your Honors.
Thank you.
244 Christopher C. v. South Slope Development Corp.
Was I the only one whose computer was in and out on that one, or?
Yeah, mine was fine.
Okay. I got a flash that said something was going on with my computer.
We've lost Judge Carney. So
yeah.
There he is. You're back, Judge Carney. You're back here. I moved on. That's all.
Showing up.
On you.
May it please the court. Good morning. Should I begin, Judge?
Yeah, go right ahead.
Okay. Judge, this case involves a ski accident where the plaintiff went down the same trail 2 occasions. On the first time the plaintiff went down this trail, she was able to handle it without any difficulty, and she makes that statement in the record. So,
Counsel, we're very familiar with the facts of this case, and obviously in the briefs. It appears here we have on the first issue you want to address is negligence, whether or not there's a failure for the pad concrete pylons or failure to mark the vertical drop in the trail. Isn't that really the first focal point?
Yeah, and my point, Judge, is that whatever was present that day on the trail, and there's a dispute about how much was there, and I suggest to you, Judge, that it doesn't matter because the plaintiff was able to travel down that trail the first time without difficulty. She says it. So therefore, whatever was there on the first occasion gave her all the information she needed in order
so that you're saying that absolves the defendant if they were in violation of the general obligation 18, so if they were not in violation of a bunch of them, just because she traversed it once safely, then no matter what they did after that, it has no bearing.
I say that it doesn't matter, yes, because the cause of the accident was the plaintiff being out of control. She knew the lift shack was there. Plaintiffs admit they know the lift shack is there. It's 12 feet high. It's brown in color. It serves as a contrast to the snow. On the second time there, I asked her, Judge, why didn't you avoid the lift shack the second time? And she says in pages 143 and 144, oh, because I was scared, because I was by myself. Judge, that's an insufficient reason.
Well, let me ask you this question. It appears from the record that I read, maybe we have a different record, that there was a drop off at the ridge. And the question, there was a lot of focal point on being marked or not marked, because as you know, understand, you have an obligation to mark what's there to be either latent or some defect or whatever it may be. And there's an awful lot of testimony on whether or not the bamboo poles or whether or not the signs were up relative to that. Well, and if that was partially cause of her let's just assume for your argument's sake, her out of control skiing, if that was partially the cause of her going into the building, why wouldn't that be a question of fact?
Because she was out of control at the time she went down, and she knew the lift shack was there.
And that goes to your argument of the sole proximate cause. That's really what you're saying. You conflate, in my view.
I'm sorry, Judge, I stepped on you.
No, in my view, in your brief, you kind of conflate the two sometimes. I'm looking at this thing strictly. Do we have this negligence cause of action? Do we have that there? Next phase. If there is, no, fine. If there is, is there enough in the record for a sole proximate cause where the court should have dismissed it on that aspect of it? I mean, to me, that's where this case breaks down to, whether or not as your argument is, it doesn't matter if the concrete pads, if they had to be, not saying they do, pylons had to have pads on them. It doesn't matter because it was her conduct, solely her conduct, that brought it about. It doesn't matter if the drop-off ridge was marked or not marked, because it was her conduct in and of itself that brought it about.
And I add to that she successfully went down the first time without any difficulty, and she acknowledges that. So she didn't need.
I'm confused. So your argument is, even though you have a statutory duty to conspicuously mark obstacle or hazards, that once someone goes by there successfully because they're a good skier or they're under control, you know your obligation to mark that dangerous area is gone?
We have the admission of the plaintiff that she knew the lift shack was present there. That's as if we didn't mark a bare spot there and the skier says, I knew the bare spot was there, but I hit it anyway because I was.
There is some actual question about how high the ridge is. There seems to be some variation, about 3 feet to 15 feet, whether that's what's supposed to be marked with the bamboo poles and whether it was or wasn't marked that day. You're not contesting that there's a factual question about that, are you?
No, I say there's a factual question, but you don't need to resolve the factual question because the plaintiff admits all of the eyewitnesses say she was out of control and went straight down the hill.
So correct me if I'm wrong, Mr. Kelly, correct me if I'm wrong. So what you're really saying, in essence, goes right back what I said before. It's her conduct. She's the sole proximate cause.
That's correct, Judge. That's what happens and causes this accident. I would like to just also state that with regard to this issue of padding, nothing in the statute requires us to pad the lift shack. It's a completely red herring for you, Judge. The statute is clear and the regulations are clear. We have to pad lift towers because that's specifically in the statute.
That's correct.
And we have to pad things that are less than 6 feet tall that are on the trail.
But I think their argument is the fact that this was so close, it was on the border of it, that it should have been marked.
But the statute doesn't say anything like that. In your case law in the Fourth Department says, we look at the statute and there's nothing in this argument and nothing in this statute that can be flexed like a rubber band. So
I would think the strength of their argument is really the failure to mark the drop off as opposed to failure to pad the pylon. But yeah, we have your argument, Counselor.
Thank you so much for your time, Judge.
Thank you. Mr. Smith?
Thank you, Your Honors. Judge Niemeyer really put his finger on it when he talks about the statutory duty to conspicuously mark the dangerous area. And that's our entire point, as we went to great lengths with our expert support to show, first of all, that Song Mountain or Slope Development Corporation, which is the operator of Song Mountain, acknowledged that this drop-off, which you're correct, Justices, that it is a factual discrepancy on whether that drop-off is anywhere from 3 feet to 15 feet. But all of the defendants' representatives agree that this was a safety hazard. It needed to be marked. There's certainly questions of fact between discrepancies in multiple witnesses on whether it was or was not marked. This is not a question of whether we're dealing with an inherent risk of injury in the sport of skiing. This is a negligence argument on behalf of the defendant to failure to protect the plaintiff from an increased hazard, a man-made hazard. And by their own admission, those warning signs and barricades should have been there. And at least there's a question of fact on whether they were or were not. We believe Judge Del Conte in the lower court below got it correct. Plenty of issues of fact. This case should be held over for trial.
Thank you, Counselor. Have a good day. Thank you.
Thank you.
Next case is 245 Cotter v. Lasco, Inc.
Okay, Mr. Davis, I think we're waiting for opposing counsel.
Okay,
So bear with us and then I'll let you get going. How's that?
sounds fair.
Okay, we're ready to go.
Okay, good morning. May it please the court. My name is Mark Davis. I represent the defendants, appellants. Plaintiff has 2 claims here. The first point I want to make.
Let me try to help you out a little bit, Mr. Davis, because holy cow, this is like a law school question here. Got 2, but why don't I have you start at least with the exposure claim and why you think it's the claim is untimely.
Sure. It's undisputed that the plaintiff was diagnosed with asthma in 2003. The lower court focused on a medical record I included with my motion. Lower court decided that it was not an admissible form, and therefore I never met my burden. I take issue with that. I think it was an admissible form. It was discussed at the plaintiff's deposition. It's never been objected to by the plaintiff. There's no.
Your argument is you don't need it anyway. In other words, even if it wasn't, even if the court was correct in saying it wasn't admissible, you got the deposition testimony of the plaintiff, and you also have the workers' comp claim that there was some illness back in 2003.
Correct. I don't need the record. The testimony is crystal clear. There's even an affidavit in the record, and the plaintiff's brief talks about being diagnosed with asthma in 2003. The trial court also said there was an issue of fact regarding causation. That's just the wrong analysis.
Your point is that under that section of the CPLR, 214-C, subdivision 2, I think it is, that it's from the date of the discovery of the injury and not when there's a connection made between the symptoms and the cause.
That's correct. The Court of Appeals has said that. And most recently, I found this case after my original brief, and I put it in the reply. The first department in 2020 said it's not computed even from the time of diagnosis or when they learn the actual cause of the symptoms, but when they start treating with the provider. Here, he was actually diagnosed in 2003. He treated for a period of time before that, but as of 2003, he's on prescription medication for respiratory issues. So it started, the 3-year clock started ticking in 2003 at the latest. It probably started ticking earlier, But, to file this case in 2014, the statute was long expired in 2014. That's the issue I want to raise on the statute of limitations and exposure.
Okay, what about, you want to get onto this out of possession landlord issue?
Sure. Again, and with that issue, the court and plaintiff's counsel focuses on the lease not existing, and therefore there has to be an issue of fact. It's my position, obviously lease would be the best evidence, but unfortunately there was a massive fire and the lease was destroyed in 2013 before this case was commenced.
Isn't the problem for you, your client's wearing a couple different hats, and he even admitted to that, or Mr. Smith, I guess the sole shareholder of this corporation, he even admitted, we're splitting hairs here. So, when you're the sole shareholder and then you're the you're the boss at the Niagara Lubricant, and he doesn't even know. He says we're splitting hairs. How are we supposed to know what the duties and the obligations are of each of the landlord and the tenant without a written document?
Yeah, that's correct. He was a little loose in his deposition testimony. He is the owner of Niagara Lubricant, the plaintiff's employer. He is the owner of the entity that owns the real property. And he did make a comment. I think he said something about loosey-goosey is what he said, but he was asked specific questions by Mr. Licata at his deposition about who's responsible for maintenance, who's responsible for improvements, who's responsible for repairs. And every answer was Niagara Lubricant would take care of all of that. So, even in cases where the lease is in evidence, the courts look at the lease, but they also, the key is control. Who was in control of this property? It's clearly Niagara Lubricant based on the deposition testimony and Mr. Smith's affidavit. And
I don't read his testimony as being at all clear about who was in charge of anything. He just seemed to say, well, we're all running together, but it's certainly far from clear. And when you use that word clear, it just jumped out at me. I did not find his testimony. And absent the lease, I don't see any clear testimony on this record.
Okay. He was asked specific questions and he answered that Niagara Lubricant would be responsible for that. And also the other point I want to make is that LASCO has no employees. It's just a holding company. So really, it can't do anything. So the out of possession, if you buy the statute of limitations argument, the exposure claim's out. I have a notice argument about the slippery condition, the grease, the trip and fall. So the out of possession landlord, it applies to both. But if it's late or if there's no notice, we don't have to deal with the out of possession landlord argument.
Yeah. So why don't we go on to, I understand your argument is to Mr. Smith is that he's really just an employee and therefore the plaintiff is stuck with workers' comp. And again, the lower court talked about a special employment doctrine. That was never raised by any party because he is an actual employee of Niagara Lubricant. He's an actual co-employee of Emmett Cotter, and Emmett Cotter is receiving workers' comp, so he can't sue his co-employee. And he's also the sole owner of the employer, so he's arguably his employer, but he is in fact his actual co-employee. Okay. I think
on the slippery, on the slip and fall issue, there was focus both in the plaintiff's brief in the lower court about the HVAC unit, the fumes. This argument is only addressed to the slip and fall. So anything regarding fumes, I'm not arguing that nobody had notice of fumes or whatever.
No, we understand that. We're talking about, when we're talking about notice, you're getting into the other cause of action, that is the negligence for the dangerous condition, the slip and fall. And as I understand your argument is you didn't create it. Mr. Smith wasn't even present on that day. There was no notice, constructive or otherwise, and therefore there's no liability.
And the Mercer case is in my brief, but that's a really helpful case because that involved a garage with vehicles that had oil in it. And that case says that, just a patch of oil or grease isn't negligence in itself. Now here, the plaintiff worked in a grease factory, so it shouldn't be surprising that there might be grease in the facility. This was not a large oil spill. This was not, a tube of grease. The only evidence of what he slipped on was a non-party employee of Niagara Lubricant, said it was a small coin size piece of amount of grease. Emmett Cotter came in that morning about an hour before he tripped and fell. He didn't notice it. Never any complaints. Nobody noticed it until after he slipped and fell. So without some evidence of, a LASCO employee, or which there are none of, or Mr. Smith himself creating it, or any evidence of notice, that was my argument. That's why the slip and fall should be dismissed. And again, LASCO has no employees. The court talked about an issue of fact regarding the workers having notice about people trafficking grease around the plant. Any one of those workers would have had to have been an Niagara Lubricant employee. They're not a defendant. LASCO had no employees. So no employee of LASCO, it's impossible that they would have had notice of any dangerous condition, which I don't think existed in the first place. And Mr. Smith, he wasn't even there. So how could he possibly have created this or had notice of it? And even if he did, he's an employee of Niagara Lubricant, not LASCO.
We have your argument, Counselor. Thank you.
Thank you.
Counselor?
May it please the court, I'm John Licata. I'm here on behalf of Emmett Cotter, the plaintiff respondent in this matter. I think, as Your Honor had said, it's a lot like a law school, lengthy law school examination we've got going here. Which would you prefer I address first?
Well, I'll let the justice presiding answer that.
If you'd like to start out with then why don't you start out from backwards, start with slip and fall. And break back.
Well, there is a Labor Law 200 claim here. And so notice issue is a little bit different under labor law than general negligence. While the principles are similar, there is an obligation on the landowner, whom we know as LASCO, to undertake inspections and has an elevated duty to see and discover defects that can be discovered and to render the workplace safe for the workers. Mr. Smith, defendant Smith, had testified that he was at this factory or facility every day, and that LASCO, while he is LASCO, and that in and of itself is a separate question, he then would be aware of the conditions. Plaintiff testified. Okay,
but so your position really ultimately is he's got constructive notice because the workers regularly track grease through. Is that what your position?
Yes, Your Honor, that there's constructive notice, and we relied on the Wesselec versus Jumping Cow that of an ongoing and recurring condition, which was testified to by Mr. Cotter and by
the young lady that worked there.
Yes, Your Honor.
You understand your issue is a recurring condition. It happens all the time. There was grease in the basement, and that you can't just say, hey, I incorporated something. I don't have any employees, so I could never be on notice.
That's precisely our position, Your Honor.
Okay, well, I want you to deal now with the untimeliness of the claims, or the timeliness of the claims.
The claim itself, they have the burden on summary judgment to eliminate any question of fact, which we don't believe that they have done. However, raising a question of fact, relying on the Johnson and I believe O'Halloran line of cases, Mr. Cotter testified that this condition would show up every October and would go away every April.
Yeah, you really have to establish that one of those two cases are applicable to this, because that's your real problem. You understand that it's really to get the benefit of this or to save your case, it's the discovery of the injury. But your argument, at least under O'Halloran, is that similar to that case, it was a single isolated instance. This happened just in the winter. It just happened on occasion. And so your client really didn't have knowledge of the injury for some time.
And that not just knowledge of an injury, but that the injury was inconsequential in the sense that there was no lost time. There was no workers' compensation claim filed at that point. He had treated for what he thought was not bronchitis, but an infection, got Z-Paks, got antibiotics, and they would go away.
That's the Johnson case you're speaking of.
Yes, Your Honor. And
yes.
In that respect, I'm sorry, somebody talking?
Yeah, I am. I'm sorry. It's hard. I know it's difficult with this Zoom. But as I understand your argument, it's not the same injury. In other words, you had a cold, you had a little bit of a mild asthma, and then this developed into a much greater condition, similar in a different condition, similar to the Johnson case.
Yes, and I would just like to point out that the letter, which is being relied upon or not relied upon from Dr. Fitzpatrick, had an examination which showed that the lungs were clear and that he did not hear wheezes or crackles. And then he says it's probably due to mild asthma, probably aggravated. And Mr. Cotter testified he never was told about this aggravation aspect, and that sometimes you get mild asthma as an adult, which is something I personally have experienced, and others as well, that asthma can afflict someone in an industrial society at any age.
Okay. Anything else, Councilman?
I want to talk about the out of possession landlord defense, which the testimony that I had submitted, and initially in the record, it was in the pages were on quarter sheets, so I had submitted it as an addendum, was that Mr. Smith testified that there was essentially no lease agreement between.
Yeah, we recognize that the problem.
Okay, and I just wanted to say, combine that there was no lease agreement with a Labor Law 200 case or Labor Law 200 claim. This is not just a simple negligence aspect, that there's a heightened duty on LASCO, and that you cannot hide behind a corporation, simply an underfunded corporation, which LASCO apparently was, to avoid responsibilities that you have as a landowner, which seems to be what's happening here.
Okay, Council. Thank you very much. Thank you both.
Thank you.
Your Honors.
246, Ocho Sinsky v. Hurley.
Judge, I think he may be having video issues.
Yeah, I see a hand up saying stop.
I think he should be able to talk.
Sam Capizzi here. Can the court hear me?
Yes, can hear. Yeah, we can hear you. So we can't see you, but I'd like to say to both of you, good afternoon. I heard the church bells going off, so it must be noon. Okay, Mr. Cantone.
Good afternoon. May it please the court, Peter Cantone on behalf of the appellants, Vincent Hurley and Whitelaw Trucking, Inc. This is the appellant's motion for summary judgment under the serious injury threshold. As an initial matter, I think the appellants clearly met their initial burden on this motion for summary judgment by submitting the affidavit.
Okay, presuming you've met your burden again, counsel, this is the second time today I'm saying, how do you argue that the plaintiff did not raise a factual question?
Thank you, Justice Nemore. The affidavits submitted here by the plaintiff, two different affidavits from doctors, are exactly the kind of affidavits that the Court of Appeals and that this court has held are conclusory and speculative as a matter of law. And that's the case for three primary reasons here. First of all, the plaintiff's experts do not find any objective proof of injury. The plaintiff's physicians, their objective opinion is that the plaintiff suffers from age-appropriate degenerative changes. That's the objective finding. That's their opinion. Second of all,
Well,
there's
certainly Dr. Grayson, who has treated this patient since 1992. And in his affidavit, I have to admit, I've never seen one quite like it, where he goes by each and every year and talks about how many visits and what he treated that person for. But his final conclusion was that after the treatments following the motor vehicle accident, in his opinion, they showed new and different injuries. You're saying he can't make that based upon his records and reports?
well, the objective proof here, right, which is the medical images and the doctor's interpretation of them, are consistent among all of these three experts, which is age-appropriate degenerative changes. It's spinal soft tissue pathology, right, which Dr. Landy in his report clearly indicates these formations that are on these MRI images are degenerative conditions. They are not caused by acute injury, and they are long-standing pre-existing conditions. And Dr.
The person
Simmons
who treated him as a chiropractor for all those long years beforehand says that they are qualitatively different than what he treated him for after the accident. On top of that, we do have an EMG that shows some problems. We do have the fact that the plaintiff received epidural injections in an implant of a spinal stimulator a couple of years after the accident from Dr. Pierre. And then we finally have the expert affidavit of the surgeon who says, I performed laminectomies upon this plaintiff, and I say they're related to the accident. Isn't that the typical, yes, even if you met your burden with Landy, isn't this the typical battle of the experts?
It's not, Your Honor, and because you need to break down each of these opinions. And so I'll start with Dr. Simmons, who his first evaluation of the plaintiff was 5 years after this accident. The Court of Appeals made clear in the Pearl case, in the Pommels case, right, that an evaluation by a doctor years later cannot reliably connect the symptoms to the accident. So that opinion.
I always wondered how you can say that when IME doctors often don't review the people until 4 or 5 years after the accident. But in this case, it's not like we don't have the patient having treatment throughout the whole time. We have testimony and records from any number of doctors, including the epidurals and the spinal stimulation. But in the end, the doctor opines, Dr. Simmons, that the surgery he performed is related to the accident.
Well, with respect to the defendant versus the plaintiff evidence, it's a different burden. The defendant's burden on a motion for summary judgment, right, is to set forth evidence that there's no objective evidence of injury. And that's clearly the case here, right? An IME doctor can do that, right? Can look at the images and say, I see degenerative conditions here, and I see no objective evidence of injury. That shifts the burden to the plaintiff, and it's a different burden. The burden then for the plaintiff, right, is to come forward with objective evidence of injury.
That the injury was caused by a trauma and not as, degenerative disc disease or all these problems we have as we start aging, with our back.
Right.
That's your point.
Exactly. And Dr. Simmons, in his report, in his affidavit, actually agrees that these conditions are age-appropriate degenerative conditions. And then he says, but I think it was made worse by the accident. And that further conclusion is a conclusion that is speculative and conclusory as a matter of law.
And that's our focus point. I mean, our focal point is whether or not, assuming that you met your burden, whether or not we have sufficient objective evidence that's sufficient enough in plaintiffs, both experts, doctors' affidavits that support a finding of a question of fact. I mean, really, when I look at these serious injury cases, they're troubling in some respects. We listen to oral argument, but really what we're stuck with is what the doctors have before us, strictly put. And so it's analysis of how we read and we look at those medical reports. And if you're correct, that they don't have the burden, that they haven't met the burden, then you're successful. If we find that the plaintiff will raise a question of fact, then it goes back. So,
Well, here the opinions of all of the plaintiff's doctors, right? We've got here Dr. Simmons, who shows up 5 years later.
Dr. Grayson, we understand that. We got the opinion position strictly is that their opinions were not based upon objective findings. And I can't make it any more clarity is that our view is to take a look at both the Simmons and Grayson's reports to see whether or not, if you're correct or not based upon objective medical evidence, then you're correct. So, I mean, I hate to say this, it's simple as that. It's a matter of looking at the medical records.
That's correct, Your Honor. And I'll just say that the Court of Appeals has set forth specific issues that come up in these cases, that they've tried to set specific discrete criteria that they say these are.
We recommend POMOs, we recommend Mo. There's got to be some objective finding. We see a number of these cases. So we'll take a look at the medical records and we'll let you know. How's that? Fair enough?
Thank you, Your Honor.
Mr. Capizzi, we can see you. How can we hear you?
Thanks for your patience. Can you hear me?
Yes, we can.
Okay. Thanks for your patience. We readjusted things. I would like just to jump in on whether the defense even got to the point where they proved their burden. Dr. Landy did not even address our central claim that this is an aggravation of whatever it is that Mr. Ochinsky was dealing with before the accident. There's all kinds of issues with respect to whether it was his hip that was bothering him in the weeks and months before the accident, and whether that had anything to do with it. And so I don't even think they've gotten to the point where they've met their burden. But as the court has said a few times, assuming that they have, and I'll pick up on where you left off, Justice Center, and that is there's plenty of objective proof in this record. The EMG alone, several cases have held that alone is sufficient objective proof. There's studies. I mean, we have Dr. Simmons and Dr. Landy essentially looking at the same studies and drawing different conclusions. And that's
okay,
Mr.
Capizzi, we appreciate the fact that that's an objective test, but you tell us how that objective test established that this injury was caused by a trauma and not by a pre-existing condition of, degenerative disc disease or all these problems we have when we get older with our backs.
Well, first of all, it could be aggravated by the injury. In other words, the accident could aggravate the pre-existing problem. But where it is here in this record is things that Dr. Landy doesn't address. And that is when we look at this history, and what I've tried to do for the court is give this a span of many years from Dr. Grayson all the way to Dr. Simmons. Before this accident, there was not one single test of CT, MRI, or anything of the nature. There was not one single referral by his treating chiropractor to a specialist. There was no need, according to Dr. Grayson in his affidavit. He wasn't suspicious of these problems. These are all objective as well, because there's an absence of any testing. There's an absence of any referral.
But you still have to link the objective test to a serious injury and causation. In other words, it's caused by the trauma, not, caused by, it just developed because it's degenerative disc disease.
It wasn't until after the accident, Your Honor, in fact, just a few months after the accident, where he had an EMG. In fact, it wasn't until the day of the accident that he even had an MRI.
Are you suggesting that the record supports the position that he was asymptomatic from the degenerative disc disease problems before?
No, I'm saying that whatever he was suffering, he certainly had at times a symptomatic condition and at times an asymptomatic condition. Because as Dr. Grayson points out, the weeks and the months before the accident, those were asymptomatic lumbar spine conditions. Those were directly related, according to Dr. Grayson, and not disputed by anybody, because Dr. Landy didn't mention it, his hip. So I'm not saying that this was an asymptomatic condition. This was at times symptomatic, at times it wasn't. It wasn't symptomatic just before the accident. But it's not until the accident rolls around that he even has a CT scan, which was on the day of the accident, or MRI.
You continue to say that, but so what? So he ordered some tests. That's the inquiry just begins there. Now we have the test. I'll give you that it's an objective test. How do those tests establish on this record that the injuries were caused by this accident and weren't pre-existing injuries or just degenerative disc disease? That's the issue.
It's
Can't you say,
intertwined.
I ordered an MRI and that's the end of the inquiry. Tell us how that doctor linked up that objective test to establish that the trauma caused this injury.
It's intertwined. I'm sorry.
Go ahead.
I'm sorry. It's intertwined with the treatment. You can't order a test unless you're suspicious of a problem. There was never, Dr. Grayson saw this man since 1992 and never had a suspicion to even order a test. The motor vehicle accident happens in October of 14 and everything changes. The nature, the extent of the complaints, the tests, all of that. So it's intertwined. That's how we get from the tests that are ordered and the objective tests, as we indicate, are interpreted. It's because it's intertwined with the treatment. There's no reason to before the accident. It's not like everybody has a baseline study. In fact, often in these cases, there is no baseline study because often in these cases, there's no reason to have it. There's no reason that Dr. Landy has pointed to, and Dr. Grayson has not pointed to either. Any reason to have this man evaluated for purposes of an MRI or CT or even an ENG. It's only after the accident. It's temporal, yes, but that is intertwined with the record of treatment that he has. This is an extraordinary record of treatment for Dr. Grayson in particular, who describes in very good detail, I submit to the court, the difference between Mr. Ochinsky before and after the accident. And even after the accident, he can't help him anymore. And he's on to a whole slew of other types of physicians that, again, he's never saw before, the types of physicians, before the accident. So there's the link, I submit, and that is the fact that there isn't any, there is this intertwined treatment with respect to testing. And before this accident, he has none of it. And Dr. Simmons comments on that as well. As a practitioner who treats people with back injuries solely, the fact that there was no prior back treatment by a spine specialist, orthopedic surgeon, but there was no prior testing, that's important to him in arriving at a diagnosis with respect to causation. And that's how he describes what happened here, and that is an aggravation of a pre-existing condition. Whether it's symptomatic or not symptomatic, it was aggravated, and Dr. Simmons describes that, and so does Dr. Grayson. And at the very least, Your Honor, we've raised the question of fact, I submit, on this issue, and that's why I believe we have juries to resolve that.
Okay. Thank you, Counsel. Thank you both.
Unless there's any questions, that's all I have.
Having none, thank you.
Thank you.
Next case is 247-248, Ryan v. Ryan. Justice Carney's recused. So have to unmute, Mr. Sarando. You know, we're going to ask you that every time. So,
pardon me?
Unfortunately, you know, we're going to have to ask you that every time. Okay.
Yes, Your Honor. Thank you. May it please the court, John Sarando on behalf of the appellant. On page 33 of our brief, there's a typo on the third line from the bottom. It should be pages 10 to 12, not page 6012. This is an appeal from orders regarding child support and maintenance, and I think the overall word is modification. And obviously, the trial court has considerable discretion in these areas.
Racine?
Yes, sir.
Racine, we can hear Timmy in the background.
Okay, sorry about that.
Okay, I'm sorry, Your Honor. And insofar as the imputation of income, clearly the defendant, the appellant did not voluntarily leave his employment. He was not hiding assets. It's based on a medical condition. The trial court, he had a job for $100,000 that he suddenly lost through no fault of his own. The trial court simply imputed $100,000 to my client without looking at any possible positions in the area, other positions in the area, and whether he could fulfill those positions with the accommodations that the respondent's expert indicated he would need. So we submitted.
Counselor, isn't this a twofold type of question? Because isn't there at some point a diligent effort need to be made by the individual to show that they've made some efforts and this is all that's available to them?
That wasn't the issue in this case, Your Honor. That the court did not put it in that file box. The court went off on he just indicated $100,000.
And that goes to your first argument you're making, is the imputing the 100,000, because
Yes.
that ultimately plays a factor with the other two issues of the child support and maintenance. Because
Yes,
if that doesn't exist, then your argument becomes stronger.
Yes, yes. I think on this record, the court was premature. When you look at the analysis that the court made insofar as the respondent and her nursing degree, and you compare that with the non-analysis that the court made insofar as the appellant, we submit that it was inappropriate and improper determination on this record, and it along with for other reasons should go back to the court to properly determine that. Insofar as the downward modifications are concerned, I think that the key is the phrase extreme hardship. I mean, that's the linchpin of what has to be shown. And in comparing the financial situation at the time of my client's application with the time of the order, clearly there is a showing of an extreme hardship due to medical conditions.
Mr. Sarando, wouldn't your client be required to make a good faith effort to obtain employment that would be commensurate with his qualifications and experience? And once he lost that position that he had at Auburn Hospital, shouldn't he have made a good faith effort to obtain other employment?
I think he was starting to do that. And I think his testimony was, I didn't start looking in other areas because I had this job. He sort of went right into that job from
Mr. Sarando, didn't he say that he only made one inquisitive inquiry about a teaching position?
At Upstate, I guess that would be the only teaching position in the area available. That's the only medical school in the area to teach at. And but he indicated that he was going to see if that was available to him. I think when the court imputed the money, it didn't indicate what the basis of the imputation was. And I think that's the critical defect in the exercise of his discretion.
Which kind of ties into your first argument.
Yes, Your Honor. Yes, Your Honor.
But let me ask you something. Is there cases that support the fact that we take a parent's, besides the earning power, you can take the parent's assets into consideration?
Well, when you look at it, yes, Your Honor. When you look at his assets, I think that there isn't the liquidity that would be readily available. I think if he had to take the money out of his 401k to support that it would be a severe tax consequences. And when you look at the chart in the reply brief, before I get to that, the court made 2 determinations of child support, as you can see. For somehow it used 17,000 in disability payment a month, when the record is clear, it was only 15,000. So we submit that those calculations are off and have to be corrected. In addition, when you look at the extreme hardship laid out in that chart, but in addition, the court found that there were certain credits that should be given to the appellant. And as the court knows, when you get into the child support arena and you have to pay a set amount to the support unit every week or every month, however it's set, that's not the place where you go and say, hey, I got some credits here coming. Please, I'm only going to make this amount of the payment. So we submit that this has got to go back for the court to give the credits on the calculation to the appellant. I mean, the credits of college room and board, health insurance for the children, and the parties agreed to an 80-20 split for college costs, and I don't think the respondent has paid any of that. So we submit on this record that there's sufficient defects in the exercise of the court's discretion and sufficient evidence to show the extreme hardship that the matter should be modified. And I don't think the record is clear enough for this court to modify it, and it should go back and be modified so it can be corrected. Other than that, I'll rely on my brief and not stand in your way for lunch.
Thank you, Counselor. Have a good day.
Thank you. Thank you.
This court stands in recess.
Okay, panel members stand.